Good afternoon. I'm Sandeep Kindo, and I'm a professor at Jindal Global University Law School. I welcome you to the thematic session on radicalizing the theory, postmodernism in jurisprudence. Some critics underscore the failure of modern, mainstream, or generalized and distinctive legal method-based jurisprudence for explaining the law, which is often complex and diverse in the multicultural contemporary. Therefore, postmodernism in jurisprudence is an interpretive effort to offer unique and critical insights to understanding law and legal decision-making. In contrary to the universal truths or generalized or foundational and existential theories of jurisprudence, the postmodern effort focuses on the particular with law, politics, and cultural considerations. Postmodern's interpretive aesthetic explores and describes the construction of legal texts, narratives, and institutions as influenced by historical, linguistic, social, or cultural aspects. However, is it possible to reconcile modern and postmodern jurisprudence? What are the implications of postmodern jurisprudence with the future of legal studies? Our objective in this session is to share some of the thinking about what implications postmodernism has for jurisprudence. There are three panelists in this session. Professor Dr. N.K. Jayakumar is an eminent jurist and the law advisor to the Chief Minister of the state of Kerala in India. Professor Dr. Ranbir Singh is the former Vice Chancellor of the National Law University, Delhi, and is the council member of the Association of Commonwealth Universities, United Kingdom. Professor Dr. Martin Škop is the Dean of the Faculty of Law at Masaryk University, Czech Republic. This session is streaming live on YouTube, and a very diverse audience comprising law students, academics, and practitioners have logged in. I will take a few questions from the audience towards the end of the session and conclude the panel. I now begin with asking the first question to the panelists, and each panelist will have 3 to 4 minutes to respond to each of the questions. And we can start with Dr. Jayakumar. The first question is, how does postmodernism offer an alternative to legal theories in jurisprudence?
Thank you. In fact, your question, how does postmodernism offer an alternative to legal theories in jurisprudence? But I doubt whether postmodernism has offered an alternative to legal theories in jurisprudence. Postmodernism itself is not a unified movement in jurisprudence, but there are different voices, different versions. With the result that postmodernism means many things to many people. It doesn't have a uniform body of ideas. But of course, there are certain central ideas which we can identify with postmodernism. And even their differences of opinion you may identify. We all agree that what we describe as modernism, following Enlightenment, has inspired or provoked jurisprudence to come with an alternative. This alternative, of course, is against so many established things in legal theory, challenges the meta-narratives, and attempts to offer an alternative through interpretivism or philosophical hermeneutics, whatever. But now the question is, as far as India is concerned, we have not even understood properly legal modernism. The legal theories which are associated with so-called modernism, like law and economics or feminist legal theory or critical legal studies. Even these strands, schools of jurisprudence, have not found sufficient attention from the academia in our country. So discussing postmodernism in this context is a little, an adventure, I feel. But at the same time, there are so many things which are very relevant to the Indian context in the postmodernist concept. One is the multiculturalism that is very much there in our society, where theories of law which were propounded and nourished in legal systems which do not have this kind of a multicultural society, so much pluralism, may not be suitable. The integrated theories that have come. But we have been following, or we have been slavishly following the theories of legal positivism or the natural law theory, the conflicts and contradictions between these theories. But I feel that even, Kelson's theory has not been properly discussed, understood in India. I have heard Supreme Court judges, not less than 2 Supreme Court judges, in my presence on the same platform, stating that Constitution is the grand norm of our system. When I tried to point out that it's a mistaken idea of grand norm, Kelson never meant a constitution to be the grand norm of a legal system. These judges were not able to absorb that idea. So, modernism as well as postmodernism have not received any attention from the jurisprudence in our country. And I'm sure that this discussion will initiate law students and faculty who are present in this program to attempt such an exercise, academic exercise.
Dr. Jayakumar, let's move to the next panelist because we're going to come back to many of these related questions again, and we'll delve into some of these aspects in more detail. Dr. Ranbir Singh, please.
Let me start with Lloyd, the very famous jurist, who said, postmodernism is a notoriously ambiguous concept. Taking a clue from what my dear friend Professor Jayakumar said, that the concept, it has no clear definition. Different people have to say different things. So the period of postmodernism is well described by Toynbee as one of the anarchy. And I don't think when we say it is a period of anarchy or kind of a concept which is more based on this kind of a concept of total relativism as opposed to the modern period. As in the middle class is marked by, we know that there was social stability, there was rationalism, there was progress. At the same time, postmodernism is a time of just reverses, time of troubles, collapse of rationalism and progress. Thus, postmodernism is a movement against modern styles. In fact, the later part of the 20th century saw the rise of postmodernism to the forefront of legal theory, as we know. Postmodernists are also referred as anti-foundationalists. They in fact shake the very foundations of law in which we believed it was built. So the students of critical legal studies, the movement which generated a long back, CLC we call it, claimed that law cannot have any foundation, as they believe there is no foundation for objective knowledge of any law. So they tend to break those stereotypes, in fact. So postmodernists argue that the principles of law could never reflect the universal truth, as we believed earlier, the modern times. According to these scholars, it is senseless to talk whether the law is right or wrong, moral or immoral, as they note the law is whatever the most powerful cultural group in society makes it. And there also is a difficulty. Sometimes we have to find out or have to really go into the background of who the most powerful cultural group is. So that is also a kind of a very, very conflicting situation. If one has to pigeonhole the postmodern legal reconstruction, actually, the basis would be that postmodernism undresses the judges and law. They make it more, bring it to the forefront, the truth of the law and what is happening in the courts. And makers of the immortal authority to determine truth that governs the society, that we were led to believe this. The influence of postmodernism in law raises bedrock challenges to the legal system alike. If law is not objective, if it does not embody values to which we all should have, then why and also criticize to be bound by it? If law is a naked assertion of power, as they believe, by one group or on another, so postmodernist theory are exerting a huge influence in the courtroom and also the legislature, despite difficulty in measuring such influences. I think this backdrop is very, very important for understanding postmodern jurisprudence. We can take it.
Sure. Thank you, Professor Dr. Ranbir Singh. Professor Martin, please.
Thank you very much, and good afternoon. I will agree with previous speakers just to say that postmodernism is very difficult to define. We can consist of many theories, movements, persons, from, I don't know, Michel Foucault, Jacques Derrida, Lacan, and Lyotard, and many other, not only French, but also German, American, English, and worldwide known academics. But the question was, if it is alternative to legal theory. I'm not sure, just because I'm not sure if it is alternative or, as Professor Ranbir Singh mentions, the progress or the development. Because the postmodernism tries to be more sensitive, aware, or critical, to try to get the justice or the social justice in society and in law, to be aware that many concepts, many legal terms are in favor of only one movement in society. And the postmodernism can offer us some possible instruments or possible tools or theories to try to establish the critical approaches to the power rooted in society and rooted in law. So from the pure theoretical approach, it is alternative. But I think that this is not alternative, but development of the legal theory. Thank you.
Thank you, Professor Škop. I think we can combine the next two questions, and they're very relevant and related. What complexity or diversity in the law allows postmodernism a say? Is it possible to reconcile the mainstream jurisprudence and postmodern's ideals of multicultural or varied and circumstantial explanations of the law and legal decision making? These are the two questions, and they're related. Professor Jayakumar.
Yeah, it's better to combine these two questions and discuss. What complexity or diversity in the law allows postmodernism a say? In fact, not really the complexity or diversity in the law, but rather treating law as a system which does not accommodate pluralism or cultural diversity. In fact, law and culture is one of the recurring themes in postmodernist jurisprudence. And the failure of mainstream legal theories is perhaps their inadequate attention being paid to the cultural aspects of that. There's a multiculturalism that in some societies exists in some societies. Now, I doubt whether it is possible to reconcile mainstream jurisprudence and postmodernism, because the basic premises are different, approach is different, perspectives are different. So when we speak of postmodernism, they deconstruct. But deconstruction is, of course, it has a negative dimension. So they have to reconstruct as well. So deconstruction and reconstruction, which is a continuous process, which has to go on in order to revitalize a legal system. This is what postmodernists envisage. Whereas the mainstream jurisprudence is rather bent upon or fixated upon the idea of a unified integrated system. So it is difficult. Reconciliation of mainstream jurisprudence and postmodernism, I think, is not a possible task. Varied and circumstantial explanation of the law and legal decision making. Legal decision making again, especially when we put the focus on the judicial decision making. Postmodernism, I feel, is not very new. When Cardoso was speaking to the students of Yale University in the year 1921, which subsequently got published as a book, Nature of the Judicial Process, he was speaking about judges taking decisions when choices are there. Choices are inherent in the judicial process. The judge's personality, the social background, how he was brought up, what kind of people with whom he interacted. So many factors which totally make up the personality of the judge will play a decisive role in judicial decision making. So when postmodernists say they may use a different terminology, but the essential idea, I think, is the same. As far as India is concerned, there are so many themes which are essentially, they deserve to be and basic origin of the, yes, and how do the basic structure theory from a postmodernistic perspective. So even from the mainstream jurisprudence angle, we have not approached such a fundamental constitutional development in India. A revolutionary concept has been introduced by the judiciary, but a jurisprudential analysis of that concept is yet to be made. Postmodernism can definitely offer valuable insights to understand our constitutional doctrines, our judicial decision making, the process, as well as the conflict of values that are involved. So I don't think that the possibility of reconciling mainstream jurisprudence and postmodern ideals and multicultural and varied circumstance explanations is not a task which we have to attempt. Let each pursue its own path. Postmodernism has its own approach, even though, as my friend Ranbir remarked, postmodernism is not a unified thought process. It is not to be understood easily. There are several streams of thought which are identified as postmodernist.
Dr. Jayakumar, we'll come to the approach and different streams in a bit. Let's get a quick response from Dr. Singh.
Sure.
Sure. My concern, the whole discussion is postmodernism has some extent lacked crucial characteristics of modern society in a number of ways. As postmodernism has led to the inadequacy of traditional social categories, say, for example, we take African Americans. In that context, if we will look into this, the International Court of Criminal Court was formed to try to those who commit crimes against humanity. But because of social differences under postmodernism, the ICC has only tried Africans. No single white has been tried for it, even when whites themselves commit such crimes. For example, American soldiers in Iraq have committed several crimes, but they are not tried. The above statements, provisions of the law and actions of the international organs have done nothing but to leave world social identity fractured under postmodernism, instead of it creating social harmony, and breaches the social differences, and there is no room for reconciliation. So in that situation, postmodernism theory has created more uphill than good, as in the modern age is the individualistic tendency in postmodernism, which looks at the individual other than the societies. It advocates for man for himself. This has resulted into tribalism, racism, poverty, hunger, since every man is for himself and no one cares for the other. In Europe, where postmodernism is the order of the day, most people don't know their neighbors. When one gets an accident, instead of being helped, other people just bypass him or her. This has created conflicting narratives, incongruable points of view, and now to be a person is to be more or less conventional location for the eddies and cross currents of various words, images, pictures, and other representations that intersect in some way at some given point in metaphysical space. This clearly shows the lack of modern characters. They argue that traditional culture, theory, politics, spacious invention, intellectuals in search of a new discourse and sources of culture capital. However, the emerging postmodern discourses and problematic raise issues which resist easy dismissal of facile incorporation into already established paradigms. Even though postmodern theory is against traditional culture, modern theory, and politics, it has not entirely ignored it completely. For example, postmodernism is also a response to called the legitimization of the crisis. It is argued that modern bureaucratic state has become dysfunctional because it colonized the other world, has interfered with the functioning of the systems. If you go by Santos, who argues that social relations interact, merge and conflict in dynamic, volatile combinations, and bring back the place where it was not before. For example, postmodernism has encouraged the alternative dispute resolution and community policing. This has done of course, a positive step. And to illustrate, the Arbitration and the Conciliation Act, the Civil Procedure Rules have both provided for the alternative dispute resolution instead of litigation in courts. This indicates that postmodernism has accommodated traditional modern age within itself. So it is not all the time that it has rejected what was modern, but it has also accepted what was modern, but in a different light, in a altogether different situation.
Thank you, Dr. Singh. Professor Škop.
Yes, thank you. I think it's difficult to say, again, just because the postmodernism will never be mainstream in society and in legal thought or in legal philosophy, just because it is against the iron cage of everydayness and of rationality of normal culture. we are ready to think in some way. We use hidden, secret, or covered speech or language layers. This is our everydayness. And the postmodernism is a critical approach to doubt these layers in our speeches, in our language, and in our thought. And through this difficultness, it will never be the mainstream. It will be still some minor part of legal and social thought in a society. But, or however, it is important to criticize these layers, these power holders, just because the space for postmodernism is in societies that are homogeneous, they are not multicultural. Just because, well, there is a unity in society, or we can say so-called unity in society, we are forgetting a specific parts of it, the gender issues, the racial issues in some societies, specific social strata issues. So there is no homogeneous society, and the postmodernism tries to speak about this for some members of society, hidden parts of society. They try to speak about minor social strata, about genders that are not in our everyday speeches. And this is the space for postmodernism. And it also means it never be the mainstream, just because of the impact laid on something we can call problematic issues and problematic questions in society. Thank you.
Thank you, Professor Škop. I think in many ways, the panelists have also answered my next question, which was, should postmodernism offer interpretive strategy standards for understanding law? And I would open it to the three panelists if they think they would want to add more to address to this particular questions. I know in the previous answers, many of you have covered some of the aspects. So the question was, should postmodernism offer interpretive strategy standards for understanding law, just the way legal methods and jurisprudence has a standardized sort of framework? Is it possible, rather, can we conceive that postmodernism can offer an interpretive strategy standards for understanding law? Dr. Jayakumar, sorry, Dr. Škop, you raised your hand first. Go ahead.
Well, I'm sorry, but yes, my answer is yes, just because it offers the multidisciplinary approach to interpretive strategies. As you mentioned it as at the beginning, we should adopt the narrative strategies, but also we should criticize the normal way, so-called normal interpretive narratives in our society and in legal interpretation. Just what we have in law. We have the interpretative and strategy and application strategy. We are trying to interpret and apply the law. This is what we are doing, dealing with. And the postmodernism can offer the picture or the approach from different disciplines, from philosophy, this is normal, but from literature, from economics, from critical economics, from sociology, psychology, and any other disciplines. And this is important, not to be rooted in the classical legal approach to, for example, interpretation, but to study this text in its complexity, to study it in the context of society and in the culture, and use, for example, the literature as the very useful approach to criticize and learn at the same time the legal text, normative text, statutes, or the decision of a court. So the postmodernism can offer this multidisciplinary approach to any methodology we have in law. And I think this is the main importance of any postmodern approach to the law. Thank you.
Dr. Jayakumar.
Yeah, I will just add one more point.
Yes.
To the question, should postmodernism offer interpretive strategy standards for understanding law? Postmodernism is very often identified with interpretivism. But one thing that I want to point out is most of the postmodernists focused on language. Without language, law cannot exist. And the indeterminate nature of language, indeterminacy of language is a very important factor to be considered when we try to understand law. That is what makes interpretation difficult and sometimes, questionable. So this aspect also has to be considered while examining the interpretive strategy offered by postmodernism.
Thank you, Dr. Jayakumar. Dr. Singh, did you have anything to add to that?
Let me make it very simple, probably. Postmodernism is a general and wide-ranging term, as we have been discussing, which is applied to literature, not necessarily that is applying only to law, art, philosophy, architecture, fiction, and cultural and literary criticism, among others. Postmodernism is largely a reaction to the assumed certainty of scientific or objective efforts to explain reality. In essence, it stems from a recognition that reality is not simply mirrored in human understanding, but rather is constructed as the mind tries to understand its own particular and personal reality. And to be very, very brief, probably, in conclusion, I can say postmodernism and modernism are somewhat intertwined in the sense, and it is in reality very hard to draw a distinct line between the two theories, except for the fact that the latter developed from the former. And that process has to continue. And there is absolutely no disagreement on that. The pre-modern, and then we shifted to modern, and the transition to modern, and that is a welcome step that brought certain very fundamental and foundational questions for society, and at the same time did not offer solutions, created confusions. And in any study, this will anyway continue. And that desire for knowledge never stops, it continues.
Right. Thank you, Dr. Singh. The next question is postmodern jurisprudence primarily a descriptive project? And then how does it relate with law's prescriptive nature? In the sense that postmodernism would describe what's going on. And how does it really fit in with law's prescriptive nature? Dr. Jayakumar, please.
I don't know whether the prescriptive nature of law is accepted by postmodernists. My understanding is that they don't. Postmodern jurisprudence is, of course, a primarily descriptive project. And this contrast between the descriptive nature of postmodernism and the prescriptive nature of law, it is an obvious contradiction. But that contradiction can survive. I don't find any difficulty in a different line of thought. It's a kind of breakthrough in legal theory and legal thought. When postmodernism came with theories which are totally at variance with the existing theories of law. Even though they never had enunciated the unified theory of looking at law or defining law, they've always accepted the contradictions, the divergences, the pluralities, the cultural diversities. All these are taken care of. Now, even basic concepts like rule of law, I think there's a specific question on that. We will come to that later. Even on rule of law, postmodern theory has a different approach, totally different approach, perspective. So this does not necessarily bother us. The descriptive and prescriptive divergence. Not a big question, I think. Yeah.
All right. Thank you, Dr. Jayakumar. Dr. Singh?
Let us look at postmodern scholars like Derrida, who proposes deconstruction as a method of unraveling the assumptions in which various laws are based, and then examining these assumptions with the purpose of exposing the dogmas underlying the same. For instance, deconstruction would demand examining the notion of subject as assumed in law. That is, as an independent, self-contained, self-controlled being, how much a notion is inherently violent in other ways of existence of human being based on interrelated and interdependent nature of human beings as being constituted by totality in which they exist. So Derrida would argue that Western philosophers established the notion of a human being only by excluding and suppressing interdependent and interrelated nature of human existence. Deconstruction, therefore, encourages purposeful and self-reflective intervention by questioning the assumptions, revealing the exclusions, and by placing in the center those who have been excluded. It thus enables critics to revisit the system from the position of marginalized and subordinated. So to that extent, it is a welcome step or welcome development as far as the study of postmodernism or deconstruction is concerned.
Thank you, Dr. Singh. Dr. Škop.
Thank you for this question, because it's difficult to answer. For the first time, we have to say that it is difficult to separate between the descriptive and prescriptive approach to postmodernism. Just because to prescribe what to do is important to know what exists in society. So the good description is important condition for good prescription. And the postmodernism describes what we are doing, how we are living our lives in society, and what does the society do in effect, not only in what is spoken about, but what is the life about. So this is the complexity of sociology, psychology, philosophy, history, and so on. So of all social studies. And if we want to prescribe, and law is prescriptive discipline, if we want to prescribe what to do, we need a postmodernism description of society. So the value of postmodernism is in this description, because it will never say what we have to do or what we ought to do, because the task is not to prescribe, but only describe what is in society. Thank you.
Thank you, Dr. Škop. I'll jump to some other question, which is much more, because in the discussion we have covered subsequent questions. So let me look for some question that is a little divergent than what we have been discussing. And I think we can discuss. Some critics would argue that modern theories in jurisprudence have failed the rule of law ideal. And this is where perhaps postmodernism jurisprudence may have a say. Your take on that, Dr. Jayakumar.
In fact, in most of the postmodern jurisprudential writings, there is a rejection of the possibility of rule of law. And I've seen someone making an assertion that there has never been rule of law anywhere in the world so far. They maintain that language is indeterminate and social practices are historically contingent. there's no firm foundation upon which a theory of rule-governed behavior can rest. Rule of law requires determinate objective rules that function as guides for and secure interpretive subjects. Joseph Singer argues that if traditional legal theories are correct about the importance of determinacy to the rule of law, then by their own criteria, the rule of law has never existed anywhere. This is what I mentioned earlier. How can we understand the rule of law in a modern context with postmodern thought? Is rule of law possible in a postmodern world? Rule of law continues to play an embedded and central role in contemporary jurisprudence as a focus in the modern exchanges between positivists, realists, natural law theories, and critical theories. Now the question is whether idea of rule of law is coherent in the light of postmodern critiques of language and objectivity. So the basic tenets of postmodernism challenge the very rationale, the very existence of rule of law, and they deny the possibility of rule of law in a modern
Dr.
society.
Singh, thank you, Dr. Jayakumar. Dr. Singh, please.
There are very serious criticism against postmodernism. You look at Chomsky has argued that postmodernism is meaningless because it adds nothing to analytical and empirical knowledge. He asked why postmodernist intellectuals would respond like people in their fields when asked seriously, what are the principles of their theories? Or what evidence are they based? What do they explain? And wasn't already obvious? These are fair requests for anyone to make. If they can't be met, then I did suggest recourse to human advice in similar circumstances to the flames. In a similar vein, Richard Dawkins also says that they are intellectual imposters. I mean, that's a very strong term used, not offering any concrete solutions. And he goes on to say, suppose you are an intellectual imposter with nothing to say, but with strong ambitions to succeed in life, collect a coterie of revered disciples and have students around the world, or your pages with respectful yellow highlighters. What kind of literary style would you cultivate? Not a lucid one. Surely for clarity would expose your lack of content. So this lack of content theory on the part of Richard Dawkins speaks in a different tone as far as postmodernism is concerned. I think we have to look at these angles very, very strongly. Whether postmodernism is a kind of a modern word which the intellectuals will use in their discussions and discourse while explaining the theories of law, or it offers real-time situations. Because in the event of confusion, in the very concept of postmodernism, because people say different things, and this is a very serious question to be discussed further, whether they offer any very concrete solutions for improving law or for society, probably.
Thank you, Dr. Singh. Dr. Škop.
Thank you. I think that postmodernism supports the rule of law. But on the other side, they try to ask the questions, what is the law? Is it unbiased? Is it impartial? Is it clear? Is it equal to each member of society? Or isn't it some voice of rich people in society, of some conservative structures, for example, in society? So the postmodernism is for the rule of law. But the question is, what is the law? Is it something that we can use without any doubt, or is it something we still should doubt and problematize and criticize? And I think the postmodernism want to say, yes, why not to be under the law? But we should all the time, every minute, every second, persuade people that the law is not only the will of the leading part of society, but is something that is equal to each member of any culture. So the problem is not in the rule of law, but the problem is in the word law. Thank you.
Thank you, Dr. Škop. I will take a few questions from the audience before concluding the panel. And I have received 4 questions, and let me take the 2 and I'll state the 2 together because they are forward-looking sort of questions. And the question by the audience is, do you consider the study of postmodernism crucial enough to be implemented in legal education? How exactly can law schools be able to implement this field of study? And next question is, how would it, the next question, which is related, is how would the postmodernism theory influence the future of legal education, keeping in mind the Indian society of the 21st century? So these are 2 forward-looking questions by the audience. There are more, but I think we can start with these. Dr. Jayakumar, please.
It's a very, very important questions. I don't know whether law students have raised these questions or somebody else. Anyway, what exactly is the relevance of postmodern jurisprudence as far as the legal academies are concerned? I would say very emphatically that postmodern jurisprudence must necessarily form an important part of the legal curriculum, because it is very, very important that the law is contextualized. We have right to equality in the Constitution. We have the rule against discrimination in our Constitution, which is fundamental right guaranteed by Constitution. But what exactly happens in our society? Is there equality in society? Is there social justice in society? These questions must also form a part of the legal education process. Recently, I saw a movie made in Tamil. Name of the movie is Jai Bhim. I don't know whether Hindi version has appeared and been shown here. But see, that is a movie which shows the plight of the marginalized sections of the community. How justice is denied, how they are tortured. One custodial death takes place in a police station. And the fight of the widow of that person who was killed by the police. And how the law can assist. There's a lawyer, a progressive lawyer who comes to her rescue. And when the case reaches the High Court, 2 judges of the High Court are also very, very humanist judges. So some justice is done. But there are situations where such situations where justice remains an illusion. They can only dream of justice, but justice never comes to them. Unless these realities also form a part of the curriculum, I would say legal education remains incomplete. So the best way to put a jurisprudential gloss to this kind of analysis is through postmodern jurisprudential studies. Yeah.
Thank you, Dr. Jayakumar. Dr. Singh, please.
The influence of postmodernism in law raises bedrock challenges to the legal system. If law is not objective, if it does not embody values to which we all should adhere, then why should citizens be bound by it? Is law merely a naked assertion of power by one group over another? Most observers concede to the fact that most modern theories of law are exerting a huge influence today in the courtroom and the legislatures and also in the classroom. That's what we were serious about, despite the difficulty in measuring such influence. Peter Shank says, postmodernism has emerged to become a dominant in legal theory as any paradigm in the past. Another author surmises that aspects of modern philosophy, postmodern philosophy, have by now through infiltrated academic legal analysis. Though the characteristics of modern society include the information revolution, like globalization, we talk, human rights, we talk, advocacy, environmental conservation, we are talking recently, and minority rights, we are serious about, emancipation is diverse. It is important to place postmodernism in a maze. Given the diversity of contemporary issues, postmodernism, of course, has acquired a very, very important place in spite of the criticism.
Thank you, Dr. Singh. Dr. Škop.
Thank you for these questions. They are very important. However, I think that postmodernism will never be a large part of legal education, just because it is difficult to find one unifying general methodology of postmodernism. So it's difficult to interpret for students and for any other audience. It is difficult to catch the postmodernism in one time and in one theory. If we try to introduce some modern techniques to legal education, like using cartoons, using artificial literature, using modern technologies, movies, whatever, it is only the form, not the content. To introduce the postmodernism in the context, we should read the text with new eyes, with new approaches. This is an important part of legal education, just to see the law, the legal rules, the decision of court from different perspectives, from perspective of deprived social strata, for example. That this never be the major part of legal education. It is important part. It is part that is needed to be in legal education, but it will, in my eyes, never be the majority for it because it's too complex and too complicated for any kind of education, not only legal education. Thank you.
Thank you, Dr. Škop. Since we still have 4 minutes left, roughly 3 to 4 minutes, maybe we can consider one more question by the audience. And the question is, would postmodernism be able to address the difficulties of a society like gender or caste bias and discrimination arising from the patriarchal society? Dr. Jayakumar.
Yeah, that's a difficult question, but I would say, the nature of discrimination, nature of injustice keeps on changing. For example, feminism wanted to focus on exploitation of women or suppression of women, but then we found that even within women, even among women, there are sections who are most the subjects of targets of oppression, suppression. Black women in America, or Dalit women in India. So a kind of Dalit feminist jurisprudence is emerging, or Black feminist jurisprudence is emerging. So, but that's why I said earlier that postmodern jurisprudence must necessarily form a part of our legal education process, because the emerging problems will have to be accommodated, incorporated. Two things I would mention now, just mentioning. One is the impact of technology. How technology has changed the concept of freedom of speech, the concept of privacy, so many things. Similarly, the pandemic has affected our lives, our rights, our duties, everything. So has there been any attempt to study the impact of the pandemic on law or legal rights and duties? No, not yet. Apart from the Epidemic Diseases Act, which was enacted in 1897, the year 1897, we don't have a legal regime to address the problems which are thrown up by the pandemic. So
thank you, Dr. Jay.
Yeah.
Thank you, Dr. Jayakumar. Sorry to cut you short. We only have 2
okay.
minutes more. I'll give you 1 minute to Dr. Singh and 1 minute to Dr. Škop. Dr. Singh, please.
Okay. Let's look at what Balkin points to 3 dimensions of jurisprudence in the postmodern sense. First, subjects bring purpose to the understanding of law, right? Legal understanding is purposive activity of subjects. Secondly, judgments about the law rest on the nature of self. And thirdly, subjectivity is important to study the law because legal understanding is also a source of power over these subjects. Legal understanding thus makes the legal subject a locus of ideological power. So in that sense, postmodernism does play a very, very important role.
Thank you, Dr. Singh. Dr. Škop.
I think that this is really important, just because the postmodernism is not only about discrimination, but it is about normality. And it means that what we consider to be normal may or may not be normal in a fact. And what we are dealing with is the ideology, as mentioned before by Professor Ranbir Singh, because ideology covers our eyes and let us to think that something is normal, something is natural, and in fact, it is not. So this is not only about discrimination, but about the covering of our eyes and mind. Thank you.
Thank you, Dr. Škop. Unfortunately, we do not have time for any more questions, but we will have the opportunity to again in the next Global Law School Summit next year, perhaps, and we will take this discussion forward. I thank Dr. Jayakumar, Dr. Ranbir Singh, and Dr. Martin Škop for their enlightening views in this session. A round of applause for our panel. Have a good afternoon and thank you.